I'm Chris Farrell, and this is On Watch. Welcome to On Watch, everybody, the Judicial Watch podcast, where we go behind the headlines to cover news and information that the old legacy media really does not want you to know about. We try to recover some lost history and explain the inexplicable. Today, we're very happy to have with us Professor Margot Cleveland, who is a journalist and investigative reporter, and now the senior legal analyst for the Federalist. Welcome to On Watch, Professor Cleveland.
Thank you so much.
Margot, you have a tremendous background. I think probably most significant, at least professionally speaking, is 25 years as a permanent law clerk to a judge on the Seventh Circuit of Court of Appeals. And that really forms, I think, a tremendous foundation for you in your legal analysis and your writing in the field on legal issues for the Federalist.
It was an amazing experience, and it definitely allows me to quickly assess a wide array of cases,
right,
legal issues, and such. So I was blessed to have that experience.
It is a fantastic foundation. And for ordinary mortals who don't, follow which circuit is which, the Seventh Circuit is in the area of Chicago, the heart of the Midwest. And you've also been a faculty member at the University of Notre Dame, which is an alma mater of yours. I was very pleased to read and gratified that while you were going to law school there, you actually were awarded the most prestigious legal award of the law school itself upon graduation.
Thank you.
It's a tremendous accomplishment. So you are well-grounded, well-suited to comment today on all the legal issues that I'd like to bring up to you. I think what really is something, there's two topics really. Number one is something that is of particular interest to us at Judicial Watch, which has to do with FBI files. But I want to address the more broadly applicable or of interest issue to a lot of Americans. And that is they saw President Trump issue a bunch of executive orders and directives across the government to enact a lot of the policies that he was elected for. 77 million plus Americans voted for him. And so he's issued these directives to various executive departments and agencies. And then we see individual district court judges on their own authority and fiat simply saying no and shutting it down nationwide. How does the American public reconcile that? How do they have a president and then some obscure district court judge who decides he's more powerful than the president is?
It is hard for the public to reconcile. And the difficulty here is to understand that sometimes injunctions against the government are appropriate. But because we have had scores of injunctions that not just were inappropriate, but grossly inappropriate, so much so that the Supreme Court would come in and throw them out and say, no, you can't do that. It is holding the courts in disregard. So when we get an appropriate injunction, we're going to have problems convincing the public that this was an appropriate response to extra executive authority. So as an example, the TikTok ban. Right. Trump doesn't have any authority to say, well, I'm not going to, we're going to give a deadline, we're going to move it on. There's no litigation on that, though. But that's a really clear case where he is exceeding his authority. Every president does it, and you do need a check. But the checks that they are giving are completely inappropriate. And you have to look no further than what happened in California, where a district judge not merely went in and said an executive order is bad, but went in and said, I don't think that federalizing of the National Guard was appropriate. He basically became commander in chief. Yeah. And that is so far beyond that you even had the Ninth Circuit within hours shutting it down.
Right.
So it is hard for the public to reconcile. I've commented on a lot of the cases. I've probably looked about 80–90% of the issues. And in those cases, they're all bad. There might be some good ones. I haven't had a chance to look at every single one, but it is absolutely outrageous.
So I guess there's two things in play. Number one is sort of the political power of the president, what a progressive Republican like Teddy Roosevelt would have called the bully pulpit, right? He gets to get up and he sort of makes pronouncements about things in an effort to sort of shape political opinion or to get a point across in the media that he wishes to advance. And it isn't legally binding in any sense of the word, but he's trying to express sort of the will of his presidency. And, you know, people can get hysterical over it for a variety of reasons.
Yes.
And that's one aspect of what we're talking about. But I think the other portion of what you just described so well is a tension or a friction that can occur that actually over the long haul becomes really corrosive to the public's sort of belief and trust in the legal system. It goes to this idea of it's all rigged, right? It's a game, and you can't get a really fair break or shake out of this. And that's a real concern to me.
Absolutely should be a concern, especially since you're also seeing blatant forum shopping, which everyone does, but not every judge then goes along with what the plaintiff wants. Whereas here, I think it's been a half a dozen district courts throughout the country have been the focus of the litigation, and they have basically done anything that the plaintiff has asked them to do, entering TROs, entering preliminary injunctions, freezing things such as firing of executive officers,
right,
ordering them reinstated, ordering grants reinstated, employees reinstated, when Congress expressly said this has to go to the Court of Claims, or this has to go to a body that deals with federal employee issues, or in the immigration context, that you don't have jurisdiction, it has to go through the immigration system. So the part is only part of the problem. The other part is we're seeing the forum shopping where the judges are making outrageous rulings. And if the public leaves that with, it really depends on, as one of my professors in law school would say, if it's a right knee-jerk judge or a left knee-jerk judge who is ruling on the case. And that is horrible for faith in the judiciary.
Yeah, and it's not just the judiciary, because really we've seen sort of this this campaign or this sort of this buildup where the American public has watched the lawfare used against President Trump with a completely, in my professional estimation, a completely compromised FBI, you know, and other law enforcement agencies and other district attorneys and states attorneys general, you know, abuse the legal process investigatively, you know, like the raid on Mar-a-Lago, which is arguably preposterous, but nonetheless was done. The efforts in New York with Judge Marchand, you know, the effort, they either wanted to bankrupt, jail, and eventually they took two, you know, efforts to assassinate President Trump. So they see this pattern of conduct, and it's not isolated. This is this goes back to 2016 with Russia hoax and FBI misconduct there. So this is a steady diet that people have been fed for going on 10 years. And then it gets to the next level, right? It jumps up into the courts. It's no longer law enforcement and prosecutors. It's now moved its way up into the system itself for legal decision. And I don't know how does this get repaired? How is faith and confidence restored? How does that work out, do you think?
Do not know. And the reason I say that is it's not stopping. It's actually, if anything, accelerating. And I think the National Guard is the example of it accelerating. You can't get any further hands-on of taking authority away from the executive than when it's acting as the commander in chief. And I envision, as you're saying this, I'm thinking through, well, what does happen? We are such a divided country now,
Right,
that I do not know how we reconcile this, other than it's going to be a long-term project of re-educating Americans on first principles, freedom of speech, and part of that is through the education system, which we have a chance to actually remake and take away from the teachers' unions who knew were in bed with the Democratic National Committee.
Yeah.
When we just saw that with the head of the teachers union stepping down from that. So I think it's not going to change in the next few years. I think it's going to take decades, just as it took decades to get where we are now. It's going to take decades with parents raising their children, teaching them, and taking over the schools and making sure that the only thing they are getting is love of liberty and of our constitutional system, and not of liberal values.
I taught journalism law at George Mason University for 5 years. It was a 400 series course in the communications department for people that wanted to have a concentration in journalism. I used to jokingly say that I was teaching a journalism law class, not as an attorney, because I'm not one, because it was too important. It's like the old joke about generals not being in charge of wars. And I was astounded. This journalism law class turned really into sort of like a 7th grade or maybe high school sophomore civics class, because these juniors and seniors at George Mason University had no idea that there were 3 branches of government, that there were courts, that there was civil law, criminal law. I mean, it was a blank canvas when I got into the classroom.
You're seeing that with some of the journalists now who are taking the approach of that Trump is acting like a king. No, he's acting like the executive.
Right.
He has power as the executive.
Right.
Now, it's not unlimited power, and there should be checks when it exceeds his power, but it doesn't mean that he does not have the authority of the executive to fire executive officials,
Right.
to issue orders to federalize the National Guard, to say we are going to be remaking these different agencies. And I do think on the plus side, we do now have an independent media who you can now see is preventing these kind of talking points from going forward, where the public doesn't hear the truth or doesn't hear a counterpoint. So that is going to turn, the next couple of decades of remaking our society in its founding image. It's going to make it easier than what we've had to deal with for the last 40 or 50 years.
I agree with you. I'm going to toss out a couple of topics that are big sort of Trump initiatives, and then maybe you can kind of come back quickly with sort of your assessment of where are we and how's it going to turn out? Kind of give me a little
Sure.
forecasting. So birthright citizenship, big question, big issue. What's the current state of play with respect to Trump's orders on that? And how do you think it plays out?
So the current state of play is that the lower courts have all stayed that executive order, meaning that it cannot yet take effect. In that case, I actually think that was an appropriate response to the executive order, because there is no harm to the executive for the courts to freeze that decision while it goes through the system. Trump, though, also asked the Supreme Court to limit the stay to the various plaintiffs and not make it nationwide.
Right.
And the Supreme Court has ordered briefing on that, and there's going to be an argument on that. And I don't remember the timing, but I would say it's in the next couple months for that.
Right.
My prediction is that they will, in this case, say that the injunction is limited to the plaintiffs. It's not a nationwide injunction. which will mean that you're going to have many more lawsuits that bring the birthright cases forward, and it will then get to the Supreme Court. It wouldn't surprise me if, while that is kind of percolating, the Supreme Court agrees to take one of the cases to decide the issues of birthright citizenship.
And that will be one of those landmark cases that will shift things one way or the other definitively.
Right. It will. And on the merits, my gut is that the Supreme Court is going to say that there is a constitutional right to citizenship if you are born in the U.S., no matter what. I think that's wrong. I think that if you look at the history, that was not what the 14th Amendment did.
Right.
But I fear that we have a couple originalists who will look at the history and think that this is just going to be making too much of a mess of history. So I would love to be wrong on that, because I think on the merits that the idea of birthright citizenship is narrower than has been used by the government in the last 50 years.
Right.
That said, it doesn't mean that the issue is done. At that point, there could very well be a push to amend the Constitution and make clear that you have to be legally and permanently present in the United States in order for birthright citizenship to play out, for your child to have that citizenship, to end this kind of maternity tourism where people fly here to have the baby, or people who are in the illegal system for years and years and years have 4 kids who are now U.S. citizens.
Right.
So that's kind of my prediction on what's going to happen in there.
I think you're right. I think it's going to be sort of a phased approach to how it all plays out, and it's not going to be a one and done. I think there's going to be a lot of layers to that question. Let me jump to another one that's, I guess, sort of a fun topic, or at least something interesting. The Alien Enemies Act. This is another one where Trump is being accused of digging up some ancient old law that doesn't matter. Which is always interesting how that's characterized. But what do you think the Alien Enemies Act? What do you think we are on that, and where's it going to go?
Right. So we still have several courts that have cases pending there, because the Supreme Court said that individuals who are targeted under this act, under the proclamation, have to bring habeas cases where they are. Some of those were made as class action lawsuits, which means that one person can represent a lot of people who may not even want to be represented. I think we're going to have a couple issues there. Whether class actions are allowed to be brought under the habeas statute, I don't think they should be, but we'll see what the Supreme Court does there. On the merits of the Alien Enemy Act, we've got a couple different issues. We've got what constitutes enough notice and enough process, and also we have, are these individuals invading our country and the other statutory requirements for it.
Right.
My thought there is that you're going to have the courts say that there's no basis in this context to say that you can exercise your rights under the Alien Enemy Act, unless the government can come forward with more evidence that Venezuela is actually doing this with the purpose of invading the United States. I frankly think this is more of a PR push than necessarily an immigration push by the Trump administration. Yes, it'd be great to get rid of these people quickly who really are terrorists and are members of these gangs, these multinational gangs.
Right.
But there are other ways that they can do it. I think it really is to expose to the public how far that the left will go to protect the worst illegal aliens.
And I think that point is well made.
Yeah,
How far will they go in order to say, you know what, we have got to have drug dealing, murdering, raping, whatever. These people are part of our community, and we love them. I mean, let them get on the record advocating for that, and they have.
Absolutely, absolutely.
Yep. I think, well, I'll throw it out and see what you say. How about DEI? Good old DEI. They've declared it dead. It's over with, and it's been extracted from the federal government. What's your read on those initiatives?
It has not been extracted. It has been hidden. So I think Trump has done great work on exposing that DEI is merely discrimination against everyone who doesn't fit whatever the hierarchy is.
Right.
I think that what we're going to see is we're going to see more details exposed about how horrible some of these plans were. We're going to see the people who are invested in it, mainly the people who have made a career out of it, fighting tooth and nail to keep it by renaming it something. But we're also going to see the Department of Justice going after people and organizations that are engaged in outright discrimination against, frankly, white men.
I agree with you. And I think, you know, one of the takeaways for me when it comes to watching this onslaught of litigation is how well organized and how sort of teed up the left was, whether it's individual attorneys or whether there's these sort of, you know, front groups running around that are all sort of amalgamated and affiliated with each other. I think of it as sort of it's like a summer camp of you know, Norm Eisen and Mark Elias. You know, they got these young lawyers together and got them motivated and charged up, and then just set them loose. The left is really good at that, and the right's horrible. You know, where was the onslaught of lawsuits and the TROs and preliminary injunctions stopping Biden from throwing open the border? You know?
Or from canceling student loans, being slapped down and doing it again.
Right.
So you are absolutely right about the left being organized and doing it, but it's not really that the right isn't. It's that the left has judges who will go along with it. Even the conservative judges, when they're faced with these lawsuits, for instance, student loan cases,
right,
they will say, you plaintiff don't have standing to do this. So you have a conservative judge acting conservatively, which means conservatives lose because they're not willing to throw out the idea of standing. They're not willing to throw out the idea of injury. So I wouldn't say it's so much that we're not as organized. We've never tried to do a coup by courts before.
Right.
And I don't think we could because it requires the courts to be on board with it. And you're not going to have conservative judges or justices winking and nodding and saying, you know what, you are divested of your powers, the commander in chief, and we're going to give it to Governor Abbott, or we're going to give it to Governor DeSantis. It's not going to happen.
There is a great irony in that. You know, it's sort of the right participates in its own destruction. You know, it's it's a very curious situation. I'm going to move to the piece or the section of discussion that is of particular interest to Judicial Watch because of all of our FOIA requests and all of our litigation on FOIA litigation that touches on matters dealing with the FBI. So a few weeks back, Senator Grassley had some records and documents, and you've written about this extensively, and they talk about FBI records that include what are referred to as prohibited and restricted files. Can you walk us through that and tell us what that means for people that are looking for transparency?
Sure. So the FBI has a system called Sentinel. It's their electronic case management system, where all of the records that the FBI creates or accumulates, so it could be a form that they use to start a case or an investigation. It could be the interview of a witness statement. It could be documents that they have seized in an investigation. That type of information is coded into Sentinel, and it is searchable then by other agents. Well, Sentinel has 3 different ways that files can be coded. Just a normal coding, a restricted access, and a prohibited access. With restricted access, if you do a search, such as for Comey and Crossfire Hurricane, any hits that are under restricted access, you would see that there was a document and who would have, I guess, control over it, but you wouldn't know what the document was.
Okay.
Everyone knew about that. Prohibited access, though, was you do the same search and it comes up no results. It makes that information invisible unless you are one of those people who has the power or the authority to search for it. That is a huge problem. Now, let me start with the idea that I can understand why you would have that. For instance, let's say that the FBI is running an investigation because they think one of their own guys is a bad guy. He is providing intel to Russia or to Iran. If that person ran their name through the system and saw that there was a hit on his name, he would know they were on to him.
Sure.
You don't want that, but you need to have checks. There has to be a way so that if a prohibited access file is searched for and someone gets that no files are there,
Right.
someone else every single time is following up. Who did the search? Why did they do the search? Do they have a legitimate reason because they need to give Judicial Watch a FOIA document? We might withhold the document, but we have to tell them we're withholding it. We
Right.
might redact the document, but we have to provide the redacted document. There is no evidence that those procedures were in place, and actually to the contrary. So I want to make 2 different points here.
Sure.
Actually 3. We'll start with what Grassley said. In Grassley's reveal, he noted that the FBI in the Washington field office had requested access to documents about Nellie Orr. Nellie Orr was, again, one of the Fusion GPS contractors who was helping with the Steele dossier, or at least doing research for the same company that was paying for the Steele dossier. It's all very,
Murky.
entwined
Right.
and murky, but all going back to the whole Russiagate collusion hoax. FBI Washington field office was investigating Nellie Orr to see if she lied to Congress.
And importantly, her husband is Bruce
Yes.
Orr, who's
Yes.
the deputy director.
Right, exactly. And they were investigating whether she lied to Congress. The FBI agents who were trying to investigate that were asking the special counsel Mueller's team that was, after he disbanded, there was still like the residuary employees.
Right.
He said, you have this stuff under prohibited access. We need to know if there's anything that hits Nellie Orr. Right there, it exposed that Mueller's team, and then digging further all the way back to Crossfire Hurricane, had put all of that under prohibited access. So that's the background for the next 2 points. I spoke with and I asked several sources, people, high level political appointees in DOJ, did you know about it? They not only did not know of prohibited access, they didn't even know the functionality existed,
Huh.
which to me is horribly troubling, because if they didn't know it existed, how would they know to make sure they got all of the
Yeah,
information?
how do you
they
even
need?
know to ask for it? Sure, they have no idea whatsoever.
Exactly. Second, I went back and looked at, I want to say it was 10 or 12 Inspector General reports on Sentinel. Sentinel was replacing another antiquated method. And I was looking to see, did it say anything about prohibited access? No. It did focus on this idea of access controls. But one of the things that these documents showed that I think is key is towards the end, they changed the requirements for Sentinel. So under the contract, it said you have to meet certain requirements. They got rid of the requirement that there was someone at the FBI who would be basically pinged if someone did a prohibited access search or did searches of things they weren't supposed to have. So it didn't say prohibited access, but it was if someone searches this. The Inspector General had a footnote that says, this is, control, internal control 101. If you don't have this, it's not going to work. But never did they follow up on this.
And it's included in the report as a footnote, and
Yes.
not as an entire chapter of discussion.
And it never came up again.
Right.
And it's been more than a decade since Sentinel was in place, and never have they audited, never has prohibited access been audited. And what I find extremely troubling is the first time prohibited access was actually referenced wasn't actually Grassley. It was an Inspector General report, I think from 2022, in an unrelated matter. It was dealing with FBI discipline. A footnote said Sentinel has 3 categories: regular, restricted access, prohibited access. That was never mentioned in the investigation of Comey. It was never mentioned in the investigation of the Carter Page documents.
Right.
And if anything, what the Inspector General did in the investigation of the FISA applications that targeted Carter Page is he dissembled. He said that the investigation was marked prohibited, which meant that the documents would be restricted to those who had, need to know. It didn't make clear that they didn't see the documents, that they were invisible, and it used the word restricted, which everybody knew about restricted access.
Right.
They didn't know about prohibited. There are so many questions that need to be answered to tell us, did Judicial Watch get what they were supposed to get? Did the House and the Senate oversight committees get what they were supposed to get? Did Special Counsel John Durham get what he was supposed to get? Did former U.S. Attorney Scott Brady, who was charged with investigating the Biden family Ukraine corruption, did he get what he was supposed to get? He went on the record with me and said he had never heard of it.
Oh,
when he
geez.
spoke with FBI headquarters trying to get access to information, they never mentioned it to him. This is outrageous. And if we didn't have a huge war going on in the Middle East, which I understand why there's a tension there, this should be on the front page of every newspaper, because it is the integrity of over a decade of highly political investigations, including the investigation into Hillary Clinton. In that case, the midyear exam, that was prohibited access.
I bet you it was. Yeah.
It was. There are documents showing that.
Do you think, well, first of all, I guess, do you have any idea, it may be too big, but do you have any idea of either like the scale or scope of documents? I'll use the Hillary Clinton email term. When the State Department told us about her server, they said there was another universe of documents. Do you think that do you have any idea of the scale or scope of the universe of prohibited documents?
Sure. So we do not have evidence on the scale or scope, but we do have some very specific information that can tell us. We know that midyear exam was prohibited access because after this news broke, I went and did a lot of research. So Midyear Exam, we know that Crossfire Hurricane was, given that Scott Brady said he had never heard of it, and given that they specifically said in these other cases, because they're high-profile presidential campaigns, I would say that was likely prohibited access.
Sure.
I would say the Clinton Foundation was likely prohibited access. I don't know this, but I can make some pretty reasonable assumptions
I
about
agree with you. I agree.
the types.
Yep.
So I don't think the average criminal defendant is going to come forward with a challenge saying, I didn't get evidence they were supposed to turn over to me. I don't think it is in every single case. I don't think it is even in high-profile cases. I think it's limited to political cases.
Right.
And even in that case, we have a half a dozen of those that involved not merely the criminal prosecution of some individuals like George Papadopoulos, like the investigation into Carter Page, who they at least didn't try to prosecute him, thank goodness.
Right.
But we also have the investigations that didn't go forward into Jim Biden, to Nellie Orr. And then we have the Senate and the House who are investigating, as well as Judicial Watch. So even though the size and the scope, I think, is probably a very small universe of political cases, I think the ramifications are still very large there.
I also think there's probably also a group of records that are enormously embarrassing to the FBI, where there's been incredible misconduct or bungled, botched operations, where agents have just essentially acted like, thugs with badges.
Right.
And they probably want to bury those as well.
And here we know from the Inspector General report that all of the investigations into misconduct were automatically coded as prohibited access.
Right.
So not only, it was a default, they actually had it as a default coding.
Right. I'm sure they did.
So you're right about the default, and some of those could have triggered other types of criminal cases beyond the political, because under disclosure requirements, the federal government, the U.S. attorney, does have to disclose impeachment evidence. So if it was a top investigator and there was something going on at the time, there might be a few cases like that out there where the evidence wasn't turned over.
Do you think that FBI Director Patel and Deputy Director Bongino have, I don't know, the horsepower or the intellect or the courage or you can pick any kind of, whatever the factor is. Will they break this open, or will this be stuffed under the rug per usual?
I think they will, and I think we have evidence that they will. Grassley went to Kash Patel and said, I want you to declassify this document. The document that was declassified within a month was the one that said the FBI has this prohibited access file. There was a reason he declassified it. He wanted everyone to know about it.
Right.
And now that he knows about it, they clearly can be doing something to see what was there, what needs to be exposed. And I think it was just this morning, it might have been last night, that he was also declassified another document for Grassley that dealt with the 2020 election. Grassley, the patron saint of whistleblowers, has a lot of folks going to him, telling them this is where they need to look.
Right.
All Grassley needs is cash to declassify things, and then it will get declassified. Grassley will expose it. And as much as people say, oh, he's going to write another letter, those letters are the breadcrumbs that are taking us to integrity. And this is how we are learning about it.
Yeah. I mean, my guess is that there's probably more than a handful of senior FBI types who are in the fetal position under their desk right now, because they know this is coming. You'll see another
I think
wave of
most of them have
retirements.
already resigned.
Yeah. Well, there's also a whole lot of people, I mean, this is very sad, but it's true. There's a certain careerism where folks say, well, you know, this is above my pay grade, and I need to get to my retirement, and nobody told me, and they all kind of want to keep their head down and go along to get along, sadly. So there's other people that were aware of prohibited files, and they said, well, it doesn't touch me directly, so, you know, I'm not gonna raise this as an issue, unfortunately.
I would also say, though, that there are good FBI agents who did not understand that the prohibited access functionality was not necessarily briefed to the Department of Justice,
Right.
or that those who should have been telling the higher ups that there are these files, they had no way of knowing that. Obviously, the Washington field office agents knew about it because they asked for access to those documents.
Right.
So, and if they're asking for access and it was signed off by 3 other higher ups, these are all good guys who are trying to get the evidence.
Yeah.
So we need more of them, though, to be the whistleblowers.
Yeah, I mean, there's a lot of knowledgeable persons who I think could, if they were energetically and aggressively doing their jobs, there'd be remarkable disclosures made. Margot, I thank you for your time. It's been tremendous. We've covered a lot of ground. But as we go to close out here, I want to give you the last word. Anything in particular that you think our viewers and listeners should know about, and then also how they can follow your excellent work at the Federalist?
I think that the main point I want to convey is what the judges are doing to enter lawless TROs and injunctions needs to stop. And the best way for it to stop is for the public to have an outrage about it. So I don't know if the best way is for you to contact Congress or if it's for you to just talk about it amongst your family and friends. But the biggest concern I have now is the lawlessness of the judges. It's not just Trump who can go beyond his authority, the courts can too. So that would be my closing comment on what to watch for. And as far as following me, I post regularly on Twitter or X at Prof MJ Cleveland. So please, follow me, join in, ask questions. I love to engage with different people to get better ideas. A lot of folks will comment and throw in thoughts I've never had. So I really enjoy the interaction.
This has been a fantastic episode, and we deeply appreciate your expertise and how you describe all these controversies and lay them out in such clear and concise ways. We really thank you for taking time to join us today.
Thanks for having me.
I'm Chris Farrell, on Watch.